December 14th, 2024. Listening.
Right.
Play. To Kimberly Forsgren. Katie Cerna. Hello. This is a new lawsuit against the LDS. We are ready to file now. Please call me so we can do the payment to file and get the summons with the new court case number. Sent from Yahoo Mail for iPhone. 24.pdf speaking email has extracted text from the attachment. David Dwayne Crossett, 650 South Main Street, number 6303, Bountiful, Utah, 84010. Email, davidx44@yahoo.com, cockroachdisability@yahoo.com. Phone, 385-424-7204, 385-215-0113. Date, December 14th, 2024. 2. The Church of Jesus Christ of Latter-day Saints. Membership and Statistical Records Division, 50 East North Temple Street, Salt Lake City, UT 84150. Subject, formal request for name removal, compliance with Utah law, and ADA accommodation. Dear Membership Records Division, this letter serves as my formal and unequivocal request for the removal of my name and all associated personal information from the records of the Church of Jesus Christ of Latter-day Saints, as required by your own policies, state law, and federal disability law. Noncompliance with Church Handbook policies, the General Handbook, serving in the Church of Jesus Christ of Latter-day Saints, last updated, August 2024, Chapter 32149, explicitly states, upon receipt of a valid resignation request, the individual's name is to be removed from the records of the Church. This language clearly mandates the removal of my name from all records, plural, including membership, financial, ecclesiastical, and archival systems across all church entities. Despite 2 previous resignation requests, the Church has failed to comply fully, retaining information beyond the stated policy. This demonstrates bad faith and violates your internal guidelines. Violation of Utah Consumer Privacy Law effective December 31st, 2023. Under the Utah Consumer Privacy Act, I am exercising my right to 1. Access all personal data the Church holds about me, including membership records, financial contributions, ecclesiastical actions, and administrative records. 2. Ensure the permanent removal of my name and all associated data from church systems. Failure to comply with this request within the statutory 45 days will result in a formal complaint to the Utah Division of Consumer Protection and escalation to the Utah Attorney General's office, which has the authority to impose civil penalties of up to $7,500 per violation. ADA reasonable accommodation request. As a person with disabilities protected under the Americans with Disabilities Act, ADA, I am also requesting a reasonable accommodation to ensure my data removal and access requests are processed without delay or undue burden. My disabilities, which include visual impairments, require that all correspondence be provided in a format accessible to me, either by email or phone. This request is made under 42 U.S.C. Section 12101 at the following, which mandates equal access and non-discrimination in handling administrative matters. This ADA accommodation is integral to my ability to exercise my legal rights and ensures compliance with federal disability laws. Required action. To resolve this matter, I require the following. 1. Written confirmation that my name and all associated records have been permanently removed from all systems and archives, in compliance with church policies and the Utah Consumer Privacy Act. 2. A complete copy of all documents, data, and records the Church holds about me, provided within the statutory timeline of 45 days. 3. A written acknowledgement of my ADA reasonable accommodation request and assurance that my disabilities will be accommodated in all communications and processes. Any further retention of my information beyond the fulfillment of this request will constitute a violation of both church policies and state and federal laws. Please confirm receipt of this letter within 5 business days and notify me when my requests have been fulfilled. I can be reached at email, davidx44@yahoo.com, cockroachdisability@yahoo.com, phone, 385-424-7204, 385-215-0113. Thank you for your immediate attention to this matter. Sincerely, David Dwayne Crossett, S. 24 Part 4.pdf Speaking email has extracted text from the attachment. United States District Court for the District of Utah. David Crossett, Plaintiff, v. Defendant, The Church of Jesus Christ of Latter-day Saints. Motion for recusal of presiding judge. I. Introduction. Plaintiff respectfully moves this court to recuse the Honorable Judge's name from presiding over this case under 28 U.S.C. Section 455, N, B, which require judicial disqualification in situations where a judge's impartiality might reasonably be questioned or where a personal financial interest is implicated. This motion is brought to ensure the appearance and reality of judicial impartiality, a cornerstone of the American legal system, particularly in a case involving significant financial and administrative implications for the defendant, the Church of Jesus Christ of Latter-day Saints, hereafter the LDS Church. 2. Grounds for recusal. A. Financial conflict of interest. 1. Mandatory tithing contributions. Judges who are members of the LDS Church are required to pay 10% of their income as tithing to maintain temple recommend status. Additionally, members frequently contribute fast offerings and other financial donations. These funds directly support the operations of the LDS Church, including administrative policies such as the name removal procedures challenged in this lawsuit. In Caperton v. A.T. Massey Coal Company, 556, U.S. 868, 2009, the Supreme Court held that due process requires recusal when there is a significant probability of bias stemming from financial ties, even if no actual bias is demonstrated. The financial stakes in this case, which could impose substantial costs on the LDS Church, create a parallel conflict. 2. Educational financial ties. Judges who graduated from Brigham Young University, an LDS Church-owned institution, have likely benefited from reduced tuition subsidized by church tithing funds. This financial relationship further strengthens the appearance of a vested interest in preserving the Church's resources. B. Religious commitments and pledges. 1. Temple endowment ceremony. As part of the temple endowment, members pledge loyalty to the LDS Church, including commitments to avoid evil speaking of the Lord's anointed and to consecrate their resources to the Church. Such commitments could reasonably lead an observer to question a judge's impartiality when the case challenges church policies, particularly if the litigation could result in criticism or financial burdens for the Church. 2. Leadership roles. If the presiding judge has held leadership positions within the LDS Church, such as bishop or stake president, this compounds the appearance of bias due to their direct role in supporting church operations and defending its policies. C. Appearance of bias. 1. Judicial impartiality standard. Under 28 U.S.C. Section 455, recusal is required where impartiality might reasonably be questioned. The objective standard, as articulated in Litigey v. United States, 510 U.S. 540, 1994, considers whether a reasonable person with knowledge of the facts would perceive a significant risk of bias. The judge's financial contributions, educational ties, and religious commitments collectively create a strong appearance of bias in this case. The case's potential to impose substantial administrative costs on the Church raises concerns akin to those addressed in Toomey v. Ohio, 273, U.S. 510, 1927, where financial interest in the outcome warranted recusal. 2. Institutional loyalty. In Ripo v. Baker, 137 S. Court. 905, 2017. The Supreme Court reiterated that recusal is necessary when the probability of bias undermines public confidence in the judiciary. The close ties between the presiding judge and the LDS Church threaten to erode such confidence in this instance. 3. Relief requested. Plaintiff respectfully requests that the court, 1. Grant this motion for recusal and assign this case to a judge without substantial ties to the LDS Church to preserve the integrity of these proceedings. 2. Provide written findings of fact and conclusions of law supporting any decision on this motion. IV. Conclusion. This case involves challenging costly and entrenched administrative practices of the LDS Church. A judge's financial contributions, educational background, and religious commitments, combined with the Church's doctrinal emphasis on loyalty and consecration, create a significant appearance of bias. To ensure a fair and impartial hearing, the plaintiff seeks recusal under 28 U.S.C. Section 455, N, B, consistent with the principles articulated in Caperton, Liddicky, and Ripoll. Respectfully submitted, David Crossett, pro se plaintiff, S. 24 Part 3.pdf speaking email has extracted text from the attachment. United States District Court, for the District of Utah, David Crossett, plaintiff, v. The Corporation of the President of the Church of Jesus Christ of Latter-day Saints, defendant. Plaintiff's motion for recusal of presiding judge and supporting memorandum. Introduction. Plaintiff David Crossett respectfully moves this court for the recusal of the presiding judge in this matter. Plaintiff's claims are based on the defendant's failure to comply with its own administrative policies and the Americans with Disabilities Act, ADA, specifically regarding the removal of plaintiff's name from church membership records following his resignation. This case does not challenge religious doctrines or practices protected by the First Amendment but instead addresses defendant's secular administrative failures and their impact on plaintiff's emotional and psychological well-being, as protected under the ADA given the presiding judge's visible adherence to LDS practices, including participation in temple ceremonies and the wearing of temple garments. Plaintiff has reasonable grounds to question the impartiality of the court. Plaintiff further asserts that his status as an apostate, combined with the cultural and religious influence of the defendant in Utah, creates an intimidating courtroom environment that undermines his right to a fair trial. Statement of facts. 1. Plaintiff's claims against the defendant. Plaintiff formally resigned from church membership and requested removal of his name from church records. The defendant's handbook of instructions outlines a clear process for removing names following resignation. Despite receiving confirmation on at least 2 occasions that his name would be removed, defendant failed to follow through, retaining his name on church records in violation of its policies. 2. ADA reasonable accommodation. Plaintiff has disabilities protected under the ADA, including emotional and psychological conditions, and requested reasonable accommodation for his name removal. The defendant's failure to comply with this request has exacerbated plaintiff's distress. 3. Religious context in Utah. The defendant wields significant cultural and social influence in Utah. The pervasive presence of LDS members in the judiciary, legal community, and jury pool raises legitimate concerns about impartiality in a case involving the defendant. 4. Visible symbols of religious allegiance. The presiding judge's visible wearing of LDS temple garments, a sacred symbol of covenants made during the temple endowment ceremony, signals allegiance to the church. This creates a reasonable perception of bias in a case where the church is the defendant. 5. Status as apostate. Plaintiff's resignation from the church identifies him as an apostate, a status that carries stigma within LDS culture. The plaintiff's lack of temple garments visually distinguishes him in the courtroom, reinforcing feelings of intimidation and alienation. Legal argument. I. Recusal is required under federal law, under 28 U.S.C. Section 455. A judge must recuse themselves if their impartiality might reasonably be questioned. Additionally, 28 U.S.C. Section 144 mandates recusal upon a party's affidavit asserting bias or prejudice supported by specific facts. 1. Appearance of bias. The judge's visible adherence to LDS practices, including the wearing of temple garments, creates a reasonable perception of bias in a case involving the church. This perception undermines public confidence in the judiciary's ability to administer justice impartially. 2. Conflict of interest from religious obligations. Judges who have participated in LDS temple ceremonies have taken covenants emphasizing loyalty to the church, such as the law of obedience and the law of consecration. These sacred commitments may conflict with the judge's duty to impartially adjudicate a case involving the church. 2. Judicial impartiality is essential to protect due process. 1. In Caperton v. A.T. Massey Coal Company, 556 U.S. 868, 2009, The Supreme Court held that recusal is required where there is a constitutionally intolerable probability of bias, even without evidence of actual bias. The court emphasized that maintaining public confidence in the judiciary requires avoiding even the appearance of impropriety. 2. In Williams v. Pennsylvania, 579 U.S. 1, 2016, the court reaffirmed that judicial involvement in matters related to a litigant creates an unconstitutional risk of bias, warranting recusal to ensure due process. 3. The intimidation of the plaintiff undermines fairness. 1. Impact of religious symbols. The judge's visible temple garments, representing sacred, LDS covenants, act as a silent but powerful signal of religious allegiance. For the plaintiff, who is litigating against the church as an apostate, this creates a deeply intimidating courtroom environment. 2. Cultural influence in Utah. In a jurisdiction where the defendant holds significant influence, the plaintiff's lack of temple garments visually identifies him as an outsider, reinforcing the perception of bias and alienation. IV. Relevant case law supporting recusal. The following cases illustrate the necessity of recusal in situations involving perceived bias or conflicts of interest. 1. Caperton v. A.T. Massey Coal Company, 556 U.S. 868, 2009. High probability of bias required recusal. 2. Williams v. Pennsylvania, 579 U.S. 1, 2016. Risk of bias from judicial involvement mandated recusal. 3. Liddicky v. United States, 510 U.S. 540, 1994. Extrajudicial bias required disqualification. 4. Ripo v. Baker, 580 U.S. 285, 2017. Appearance of bias justified recusal. 5. Berger v. United States, 255 U.S. 22, 1921. Demonstrated bias necessitated disqualification. Prayer for relief. For the foregoing reasons, plaintiff respectfully requests that 1. The presiding judge recuse themselves from this case to preserve impartiality and public confidence in the judiciary. 2. The court ensure that plaintiff's claims are adjudicated in a neutral forum, free from intimidation or bias. 3. The court grant any further relief it deems just and proper. Respectfully submitted, David Crossett, MSMS/11% JD, 385-424-7204, davidx44@yahoo.com, cockroachdisability@yahoo.com, S. 24 Part 5.pdf speaking email has extracted text from the attachment. David Dwayne Crossett, 650 South Main Street, number 6303, Bountiful, Utah, 84010, email, davidx44@yahoo.com, cockroachdisability@yahoo.com, phone, 385-424-7204, 385-215-0113, date, December 14, 2024, 2. The Church of Jesus Christ of Latter-day Saints, Membership and Statistical Records Division, 50 East North Temple Street, Salt Lake City, UT 84150, subject, formal request for name removal, compliance with Utah law, and ADA, accommodation. Dear Membership Records Division, this letter serves as my formal and unequivocal request for the removal of my name and all associated personal information from the records of the Church of Jesus Christ of Latter-day Saints, as required by your own policies, state law, and federal disability law. Noncompliance with Church Handbook policies, the General Handbook, Serving in the Church of Jesus Christ of Latter-day Saints, last updated, August, 2024, Chapter 3.2.149, explicitly states, upon receipt of a valid resignation request, the individual's name is to be removed from the records of the Church. This language clearly mandates the removal of my name from all records, plural, including membership, financial, ecclesiastical, and archival systems across all Church entities. Despite 2 previous resignation requests, the Church has failed to comply fully, retaining information beyond the stated policy. This demonstrates bad faith and violates your internal guidelines. Violation of Utah Consumer Privacy Law effective December 31, 2023, under the Utah Consumer Privacy Act, I am exercising my right to 1. Access all personal data the church holds about me, including membership records, financial contributions, ecclesiastical actions, and administrative records. 2. Ensure the permanent removal of my name and all associated data from church systems. Failure to comply with this request within the statutory 45 days will result in a formal complaint to the Utah Division of Consumer Protection and escalation to the Utah Attorney General's office, which has the authority to impose civil penalties of up to $7,500 per violation. ADA Reasonable Accommodation Request. As a person with disabilities protected under the Americans with Disabilities Act, ADA, I am also requesting a reasonable accommodation to ensure my data removal and access requests are processed without delay or undue burden. My disabilities, which include visual impairments, require that all correspondence be provided in a format accessible to me, either by email or phone. This request is made under 42 U.S.C. Section 12101 at the following, which mandates equal access and non-discrimination in handling administrative matters. This ADA accommodation is integral to my ability to exercise my legal rights and ensures compliance with federal disability laws. Required action. To resolve this matter, I require the following. 1. Written confirmation that my name and all associated records have been permanently removed from all systems and archives, in compliance with church policies and the Utah Consumer Privacy Act. 2. A complete copy of all documents, data, and records the church holds about me, provided within the statutory timeline of 45 days. 3. A written acknowledgement of my ADA reasonable accommodation request and assurance that my disabilities will be accommodated in all communications and processes. Any further retention of my information beyond the fulfillment of this request will constitute a violation of both church policies and state and federal laws. Please confirm receipt of this letter within 5 business days and notify me when my requests have been fulfilled. I can be reached at email, davidx44@yahoo.com, cockroachdisability@yahoo.com, phone, 385-424-7204, 385-215-0113. Thank you for your immediate attention to this matter. Sincerely, David Dwayne Crossett S. 12 hours, 14 minutes, and 24 seconds Part 8. PDF speaking email has extracted text from the attachment. David Dwayne Crossett, 650 South Main Street, Bountiful, Utah 84010, phone, 385-424-7204, 385-215-0113, email, davidx44@yahoo.com, cockroachdisability@yahoo.com, December 7, 2024, 2. President Russell M. Nelson, President Dallin H. Oaks, President Henry B. Eyring, Elder Jeffrey R. Holland, Elder Dieter F. Uchtdorf, Elder David A. Bednar, Elder Quentin L. Cook, Elder D. Todd Christofferson, Elder Neil L. Anderson, Elder Ronald A. Rasband, Elder Gary E. Stevenson, Elder Dale G. Rinlund, Elder Garrett W. Gong, Elder Ulysses Suarez, Elder Patrick Kieran, the First Presidency and the Quorum of the 12 Apostles, The Church of Jesus Christ of Latter-day Saints, 50 East North Temple Street, Salt Lake City, Utah 84150. Subject: Formal ADA request for complete removal of membership records. Dear First Presidency and 12 Apostles of the Church of Jesus Christ of Latter-day Saints, I am writing to formally demand the immediate and complete removal of my name and all associated records from the membership rolls and archives of the Church of Jesus Christ of Latter-day Saints. This request is being made under the Americans with Disabilities Act, ADA, 42 U.S.C. Section 12101 at the following, as a reasonable accommodation for the severe emotional distress, high anxiety, and other disabilities I am experiencing as a direct result of your failure to honor my resignations and remove my records. I have resigned from the church twice. After my initial resignation, I later rejoined the church, only to discover that my original membership number and patriarchal blessing were still intact, showing that you did not honor me first resignation. Years later, I resigned a second time, believing that this time my records would be fully removed. However, I learned through a bishop that my membership number and other records still existed, and I subsequently received my original patriarchal blessing in the mail. This demonstrates a repeated and systemic failure by the Church to fulfill its promises and legal obligations regarding membership resignations. Your ongoing retention of my personal information is not only deceptive but has caused me significant emotional harm. As a person protected under the ADA, I have been forced to seek additional psychiatric care, increase my medication, and endure high levels of stress and anxiety stemming from the belief that my name had been removed when it was not. Your actions have directly impacted my mental health and well-being, and I am requesting a reasonable accommodation under the ADA to mitigate further harm by removing my name and all associated records immediately. Specifically, I am requesting 1. The permanent removal of my name, membership number, and all associated records from your archives. 2. Written confirmation that this action has been completed. You must act on this request promptly and no later than 30 days from the date of this letter. If you fail to complete, I will pursue legal action, including hiring co-counsel to explore a potential class action lawsuit. I believe this issue impacts countless individuals who have resigned from the church and yet remain on your rolls, further compounding the harm caused by your inaction. Please be aware that I will also include you as individuals in such legal action, as agents of the corporation, under ADA law. Please take this matter seriously. Resolving this issue now, without further escalation, would not only comply with legal requirements but also demonstrate good faith on the part of the church. I look forward to your immediate confirmation that my records have been removed. Sincerely, David DeWing Crossett, phone 385-424-7204, 385-215-0113, email, davidx44@yahoo.com. cockroachdisability@yahoo.com. Official complaint Mormon Church 1214-24.pdf speaking email has extracted text from the attachment. Proce 15, Reverend. 12/16, complaint for violation of civil rights, non-prisoner, United States District Court, for the District of Division. Case No. To be filled in by the clerk's office, plaintiff. Write the full name of each plaintiff who is filing this complaint. If the names of all the plaintiffs cannot fit in the space above, please write C attached in the space and attach an additional page with the full list of names. V. Jury. Trial. Check 1. Yes, no. Defendant. Write the full name of each defendant who is being sued. If the names of all the defendants cannot fit in the space above, please write C attached in the space and attach an additional page with the full list of names. Do not include addresses here. Complaint for violation of civil rights. Non-prisoner complaint. Notice. Federal Rules of Civil Procedure 5.2 addresses the privacy and security concerns resulting from public access to electronic court files. Under this rule, papers filed with the court should not contain an individual's full social security number or full birth date, the full name of a person known to be a minor, or a complete financial account number. A filing may include only the last 4 digits of a social security number, the year of an individual's birth, a minor's initials, and the last 4 digits of a financial account number. Except as noted in this form, plaintiff need not send exhibits, affidavits, grievance or witness statements, or any other materials to the clerk's office with this complaint. In order for your complaint to be filed, it must be accompanied by the filing fee or an application to proceed in forma pauperis. Page 1 of 6, District of Utah, Division, David D. Crossett, MSMS/11% JD Cockroach Disability Law Center, checkmark, President of Corporation of Latter-day Saints Proce 15, Reverend. 12/16, complaint for violation of civil rights, non-prisoner, I. The parties to this complaint, A. The plaintiff, S. Provide the information below for each plaintiff named in the complaint. Attach additional pages if needed. Name, address, city, state, zip code, county, telephone number, email address. B. The defendant, S. Provide the information below for each defendant named in the complaint, whether the defendant is an individual, a government agency, an organization, or a corporation. For an individual defendant, include the person's job or title, if known, and check whether you are bringing this complaint against them in their individual capacity or official capacity, or both. Attach additional pages if needed. Defendant no. 1. Name, job or title, if known, address, city, state, zip code, county, telephone number, email address, if known, individual capacity, official capacity, defendant no. 2. Name, job or title, if known, address, city, state, zip code, county, telephone number, email address, if known, individual capacity, official capacity, page 2 of 6, David D. Crossett, 650 S Main Street 6303 Bountiful at 84010, Bountiful, 385-215-0113, 385-424-7204, davidx44@yahoo.com, cockroachdisability@yahoo.com. The Church of Jesus Christ of Latter-day Saints Corporation, 50E North Temple, Salt Lake City at 84150 Salt Lake City, 1-801-240-1000, checkmark, CA 94105, Prosa 15, Reverend. 12/16, complaint for violation of civil rights, non-prisoner, defendant no. 3. Name, job or title, if known, address, city, state, zip code, county, telephone number, email address, if known, individual capacity, official capacity, defendant no. 4. Name, job or title, if known, address, city, state, zip code, county, telephone number, email address, if known, individual capacity, official capacity. 2. Basis for jurisdiction, under 42 U.S.C. Section 1983, you may sue state or local officials for the deprivation of any rights, privileges, or immunities secured by the Constitution and federal laws, under Bivens v. 6 unknown named agents of Federal Bureau of Narcotics, 403 U.S. 388, 1971. You may sue federal officials for the violation of certain constitutional rights. A. Are you bringing suit against? Check all that apply. Federal officials, a Bivens claim. State or local officials, a Section 1983 claim. B. Section 1983 allows claims alleging the deprivation of any rights, privileges, or immunities secured by the Constitution and federal laws, 42 U.S.C. Section 1983. If you are suing under Section 1983, what federal constitutional or statutory right, S, do you claim is or being violated by state or local officials? C. Plaintiff suing under Bivens may only recover for the violation of certain constitutional rights. If you are suing under Bivens, what constitutional right, S, do you claim is or being violated by federal officials? Page 3 of 6, Prosa 15, Reverend. 12/16, complaint for violation of civil rights, non-prisoner, D. Section 1983 allows defendants to be found liable only when they have acted under color of any statute, ordinance, regulation, custom, or usage, of any state or territory or the District of Columbia, 42 U.S.C. Section 1983. If you are suing under Section 1983, explain how each defendant acted under color of state or local law. If you are suing under Bivens, explain how each defendant acted under color of federal law. Attach additional pages if needed. 3. Statement of claim. State as briefly as possible the facts of your case. Describe how each defendant was personally involved in the alleged wrongful action, along with the dates and locations of all relevant events. You may wish to include further details such as the names of other persons involved in the events giving rise to your claims. Do not cite any cases or statutes. If more than one claim is asserted, number each claim and write a short and plain statement of each claim in a separate paragraph. Attach additional pages if needed. A. Where did the events giving rise to your claim, S, occur? B. What date and approximate time did the events giving rise to your claim, S, occur? C. What are the facts underlying your claim, S? For example, what happened to you? Who did what? Was anyone else involved? Who else saw what happened? Page 4 of 6 Salt Lake City, Utah on or about 2007. Plaintiff resigned from Mormon Church on or about 2007. Plaintiff resigned after rebaptism again in 2011. Mormon Church assured plaintiff both times that his name will be removed from all records of Mormon Church. Mormon Church refused to follow through to remove plaintiff name either time to date. Plaintiff has been humiliated, embarrassed and has received extensive psychiatric services to recover from breach of Mormon churches to remove his name. Plaintiff has made several legal ADA accommodations requests to remove his name. The Mormon Church has refused and ignore any legal accommodations request. Pro Se 15, Reverend 12/16, complaint for violation of civil rights, non-prisoner, IV. Injuries. If you sustained injuries related to the events alleged above, describe your injuries and state what medical treatment, if any, you required and did or did not receive. V. Relief. State briefly what you want the court to do for you. Make no legal arguments. Do not cite any cases or statutes. If requesting money damages, include the amounts of any actual damages and/or punitive damages claimed for the acts alleged. Explain the basis for these claims. Page 5 of 6. Regular physician consultations, medications, therapy, psychiatric and psychologist, attempted suicides, hospitalizations, family and marital ramifications. Order the Mormon Church to completely remove, absolve, redact, expunge any and all of my records, included genealogical and any other archive database. Any and all non-public genealogical records in church archives and shared non-public records with any platform such as Ancestry.com and ECT. Any and all information on family history library and family search that contain the plaintiff's name that is not public record. $266,666.66 actual damages. $100,666,666.66 punitive damages. Courts cost legal fees $46,666.66. Pro Se 15, Reverend 12/16, complaint for violation of civil rights, non-prisoner, 6. Certification and closing. Under Federal Rule of Civil Procedure 11, by signing below, I certify to the best of my knowledge, information, and belief that this complaint, 1, is not being presented for an improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. 2, is supported by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law. 3, the factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. And 4, the complaint otherwise complies with the requirements of Rule 11. A. For parties without an attorney, I agree to provide the clerk's office with any changes to my address where case-related papers may be served. I understand that my failure to keep a current address on file with the clerk's office may result in the dismissal of my case. Date of signing, signature of plaintiff, printed name of plaintiff, B. For attorneys, date of signing, signature of attorney, printed name of attorney, bar number, name of law firm, address, city, state, zip code, telephone number,